If you're watching this video, you might be dealing with the loss of a loved one who didn't leave a will in Missouri. And first, I want to say I'm sorry for your loss. But with that out of the way, today what we're going to do is we're going to walk through exactly what happens next and what you need to know about Missouri intestate succession laws. Hi, my name is Dan Schnurbush. I'm an estate and probate attorney based out of St. Charles, Missouri. We help clients all across the state of Missouri when they're dealing with the loss of a loved one. What probate is it's the legal mechanism for transferring ownership to property to the heirs of the estate or the beneficiaries under a will. And today we're going to be talking specifically about Missouri, but a lot of these basic concepts can apply in any state. Generally speaking, what the first major step is when we're dealing with probate, the legal process, is actually compiling information about the deceased person. When did they pass away? We need to get their death certificate, all of the heirs to the estate. So were they married? Did they have kids? Did they have, anything like that? And getting everybody's contact information because the court's going to want that information. And assuming the applicant, the person who is filing to manage the probate of the estate, is qualified, assuming they're qualified, they will be appointed by the judge. If there is no will, they have to follow certain priority. In Missouri, the spouse has default priority to serve as representative of an estate or to probate the estate. Children have kind of secondary priority, and then it kind of goes out to the extended family from there. If there is a will, the will name who the representative is. So today we're talking about what happens if you don't have a will. So in this case, again, it's going to go to the spouse and to the children to have default priority. Importantly, even if you are a child and you have like a stepmom or a stepdad who's not taking the job seriously and who's not doing it, they still have a right to serve as a primary representative in Missouri. And even if they don't want to serve, they have a right to nominate someone else to serve. So if you want to serve, or if you want somebody at your direction to serve, then you're going to need to either get a waiver from that spouse, a signed waiver, or you're going to need to petition the court and have that spouse fail to show up or fail to comply with court orders before you're going to have a chance of doing that. If there's a serious risk that the spouse is going to participate, you need to get that process going quick because it can take quite a bit of time. But once the judge has decided on who is going to serve, and that person has filed for what are called letters of administration. Letters of administration are essentially just the kind of certificate of authority that once awarded to you are kind of indicate that you are allowed to transact business on behalf of the deceased person's estate. And when I use the term estate, I don't mean like giant mansions. What I mean is any property that was left in their name that didn't have a beneficiary, didn't have a joint owner, it has nowhere to go. That's property that belongs to their estate. So then the question becomes who gets what? When there is no will, who gets what? In Missouri, if you have a spouse and no children, everything goes to the spouse. If you have a spouse and children, it depends on whether the children were of that marriage or not. If you have children from outside of the marriage, like prior to the marriage, from a first relationship, and those kids are not also the children of the surviving spouse, the spouse receives a 50% interest in the estate, and the children, no matter how many you have, split the other half. So let's say you had 4 kids, they'd each get 1/4 of half, whatever that comes out to, 12.5%, I guess, something like that. By contrast, if you have children and they are the children of your surviving spouse, that spouse receives the first $20,000 of probate estate property and 50% of the balance. It goes back to that 50-50 split. They basically just get an extra $20,000 up front if the children are of the marriage. Now, this is a surprise for a lot of people. They assume that everything goes to my spouse when they die. And the reality is in Missouri, no, they don't. So if you had, let's say you had 3 little kids and you were married and they're, 2, 5, and 7, if you die and you have property left in your name, all the children are of your marriage with your spouse, your spouse is going to get $20,000 plus half, but then your little kids are going to actually get the other half. And in Missouri, because they're minors, they're going to need a court conservatorship in most cases. It might be possible to get the judge to authorize the transfer of the property into a trust. Don't count on it. So that's kind of how that split goes. If you don't have a spouse or children, then it goes out to your parents and siblings equally. okay? Meaning if you have 2 parents and 2 siblings, they would each get a quarter, right? So your parents don't get automatic priority, but your parents and siblings are treated equally. If you have no parents, no siblings, then it starts going out to collateral relatives, to aunts and uncles and their kids and grandparents and their kids. But that's kind of how the default distribution works in the state of Missouri. Something else, just a little pin in it, is that if you don't have any children and spouse, but some of your assets are going to your siblings, if you have any half-blood siblings, so siblings who have one parent in common with you but not both, they actually, the Missouri law takes the half-blood concept very strictly, very literally. They receive half as much as a whole-blood relative. Just something to be aware of. Now, there are many assets that pass outside of probate, and these property is not subject to the intestate rules. That would be property like joint accounts, like joint bank accounts, joint brokerage accounts. If you own a house as joint tenants with right of survivorship, if you own property in those different ways, that property doesn't go through probate. It automatically slides over to the joint owner. It doesn't follow that intestate distribution. And again, it's important to underscore this. That distribution, 50 to the spouse, 50 to the kids, yada, 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 that only applies for property that is subject to probate. So again, it doesn't apply to things like retirement accounts with a beneficiary on them. It doesn't apply to TOD bank accounts. It doesn't apply to joint accounts. It doesn't apply to any of that stuff. It only applies to stuff in the deceased person's name with nowhere else to go. So what is a typical timeline and costs associated with intestate probate where there is no will? Now, usually it's a little bit slower than it is if there is a will, mostly on the front end. It's a little bit harder to get a person appointed representative in some cases than if they had a will. And the reason for that is this. In a probate estate, unless it is waived or the judge doesn't require it, the person seeking appointment as representative often needs to purchase a surety bond. And in order to purchase a surety bond, they have to be underwritten, which means they generally need to have a pretty clean criminal background. They need to have decent credit. They probably need to have decent income and assets. And not everybody can qualify for a surety bond. You can waive a surety bond in a will. You can say my representative is not required to get a surety bond. That can be a significant time reduction. You don't have to worry about going through underwriting, and you don't have to worry about qualifying. And that can often help speed things along. The other thing that a will can do is it can authorize independent administration. In Missouri, anytime you have a full administration, anytime the assets are above $40,000 and it's within a year of death, you can file for full probate administration to seek the appointment of a representative, okay? And then there are 2 ways you can have full administration. It can either be supervised by the court, where you got to get a court order to do everything, to sell anything. They check every little detail that you do. And on the other hand, you have independent administration, where essentially once you're appointed, you can do whatever you want on behalf of the estate and the judge doesn't need to know about it. And at the end, you file a simple piece of paper and you're done. So very different methods of going through probate. And a will can authorize independent administration. It can specifically say my representative shall not be required to administer the estate under court supervision or something to that effect. This is very helpful. It's much easier to get somebody in the door and get appointed and get them to work much faster. Whereas if you tried it, you can get independent administration without a will. It's just that you have to get every heir to sign a renunciation and waiver form that says, yeah, it's okay if they serve independently. And sometimes it's really hard to get signatures from everybody. Either we can't find them, or they're dead, or there's some reason that makes it difficult to obtain a waiver, or maybe they just hate you and they don't want to let you serve independently. There are lots of different reasons that can come up. But having the will there can help expedite and speed that process up. But as we've talked about in other videos and on our blog, generally the time requirement for an independently administered or supervised administered intestate estate is usually about 8 to 12 months. Can be longer if it's more complex, but it's generally speaking about 8 to 12 months is a minimum of 8 months pretty much in the state of Missouri due to the 6-month creditor claim period. And usually it takes about 6 to 8 weeks to get the court to actually review your petition in many counties in the state of Missouri. Court costs are usually not too bad. The filing fees in probate are usually somewhere between $100 and $250. Sometimes there will be additional fees for inventory and other costs that the court imposes on you, usually no more than a few $100s. There are associated fees, though. In many cases, you're going to have to buy a surety bond, and that can be a few $100s. You're going to have to publish notice in the newspaper. If you're in a bigger county like St. Louis or Jackson, publishing in the newspaper is cheap. It's like $60. If you're in a rural county where there just aren't as many probate publications, you might be spending $500, $600, $700, $800 just to publish notice of your appointment in the newspaper. It's crazy how expensive it is to publish notice in more rural counties in Missouri. So those costs can add up. So altogether, you could expect to pay anywhere from $400 to over $1,000, $1,500 just in court costs and fees and surety bond fees and other things like that. Generally speaking, attorneys' fees are handled in one of two ways. Well, three ways. They will either be handled on an hourly basis, which is probably the most common. They will be handled as a percentage of the estate, which is a statutory minimum in the state of Missouri. The attorney is entitled to a minimum percentage of the estate that's based on the amount of the personal property and real estate sold under order of the court. It's kind of a complicated way to calculate it, but that's how it's set. Now, that fee is also the same fee that the representative themselves is entitled to. So if you're doing the job of being representative, you're entitled to that fee. And the other way that attorneys can sometimes get paid is on a flat fee basis, okay? At our firm, we do everything on the higher of our flat rate fee or the statutory percentage, whichever is larger when we get to the end, because percentages don't make sense if the estate is only $40,000, but it does make sense when they get larger because it's a minimum. Several different ways that court costs and fees can apply to your estate, but it's important to understand that you're, in general, looking at several $1,000s to get through the probate process in most cases, especially for a full probate administration. And the important thing to remember is that all of this is completely avoidable with some decent planning. Let's talk about other ways to bypass this full probate procedure. There are a number of different short form proceedings in the state of Missouri. If your estate is less than $40,000, you can file for a small estate affidavit in many cases, as long as you're an heir of the estate. If it's over $40,000, but it has been longer than a year since death, you can file for what's called a determination of heirship proceeding, which is another short form probate. Neither of those two kinds of probate require that 6-month creditor waiting period. Usually those are done within 6 to 10 weeks. Small estates are done a little bit quicker than determination of heirship cases in most cases, because with the determination of heirship, we have to publish in the newspaper, we have to have an in-court hearing. It's only about a 5-minute hearing, but we do have to have that in-court hearing. And so we have to get it on the court's docket in order to do that. There are a couple of different ways to bypass full probate administration that are much, much faster and consequently typically more affordable. The other way of bypassing probate in a much more efficient way is through what's called a refusal of letters application. And there are 3 types of people that can file for this. Spouses, if the estate is under a certain amount. Many counties will put kind of an arbitrary amount on it. In St. Louis County, I believe it's $24,000. If the estate is under $24,000, they will automatically grant the refusal letters to the spouse, which means probate is done, spouse gets everything. A minor refusal letters for minor children, it's very similar to the spouse. St. Louis City, I believe, is $20,000. Then you have creditor refusal, where somebody who's a creditor of the estate, which could be a family member who paid a funeral bill, for example, as long as the total estate value is under $15,000 and there are no spouse and children and other things like that, then the creditor can file and claim the estate in satisfaction of their creditor's claim. So a couple of different ways to go through shortened probate. This is why it's important to work with a qualified professional, because there are lots of different avenues to go through probate. And unless you do everything exactly correctly, the court is just going to keep throwing you back and making everything a nightmare for you. They play goalie and make sure you've checked every box and run through everything correctly. Common pitfalls in the state of Missouri: don't pay debts immediately. Most of those debts are not enforceable. Most of those credit card bills, healthcare bills, many times creditors don't file creditor claims correctly. In Missouri, you're only entitled to be paid as a creditor if you're filing a creditor claim in a full and open probate administration. So if you have a credit card bill or a healthcare bill or something else, that person is not entitled to be paid unless they go through the hoops and do what they're supposed to do. Now, there are exceptions to this. We got to be thoughtful about what we're going to do with things like mortgages and car payments and stuff like that. Because if you don't pay those, you can lose those assets. Now, in Missouri, there is a 6-month moratorium on foreclosure from the date of death, where a mortgage company, even if the mortgage is not being paid, cannot file for foreclosure for 6 months. And for personal property, I believe it's 2 months. But nevertheless, a lot of times people are coming to us outside that window, and we certainly don't want to be pushing up against it. It's important to look at things like utilities when you're dealing with real estate. You don't want to have your house pipes burst because you didn't pay the heat at the house over the winter, something like that, okay? And the takeaway I want you to get is that if your loved one died without a will, the property passes, the probate property passes to their heirs at law, spouse, children, spouse and children, parents, siblings, and there's nothing else we can do about that. So like if they had kids that they haven't seen in 40 years, they're probably going to inherit. They're probably entitled to inherit. If you didn't want them to inherit, you should have put together a will or put a transfer on death on your bank account or something like that. You should have done a little planning if you didn't want your biological offspring to inherit. This drives people nuts a lot of the time. They call in and they're like, I can't believe that we need to bring so-and-so into this process. It's like, yep, there's nothing we can do about it. Your loved one should have had a will if they wanted to express contrary wishes. The law creates a default will for you if you don't write your own, okay? And again, the process, it generally takes between 8 and 10 months, could be shorter if you qualify for a short form. So look into whether those options might apply for you. If you're not sure, you're going to need to talk to an attorney. In most counties in the state of Missouri, you have to hire an attorney for virtually any kind of probate that you're going to do. There are only a few kinds of probate that you can sometimes do without an attorney. Some counties will allow you to do small estate applications, small estate affidavits without an attorney. St. Louis City, St. Louis County are not among them. If you're in a more rural county, you might have better luck filing for small estate without an attorney. It really depends. Sometimes you can qualify for refusal letters without an attorney. But I do encourage you to make sure that you're well advised on what you should be doing as you go through this process. There are a lot of pitfalls, and doing it right the first time can save you a lot of grief. If you want to learn more about probate, click the links on the video and check out some of our other videos about probate in the state of Missouri. We'll see you next time, guys. Thanks for watching.